Mr. Chairman, this frivolous hearing is just another misguided attempt by the majority to undermine and discredit the Affordable Care Act. Despite the best efforts at sabotage by the majority across this country, implementation of the law carries on, and my friends on the other side of the aisle can no longer ignore the great good that the Affordable Care Act is doing for the American people. The uninsured rate has now dropped to 15.6%. 8 million Americans have enrolled in comprehensive affordable private health insurance coverage through the Federal Exchange. 5 million more Americans have enrolled in private ACA-compliant insurance plans. 3 million young adults gained coverage by being able to stay on their parents' plan. 3 million more people were enrolled in Medicaid and CHIP as of February compared to before the marketplaces opened. 129 million Americans with pre-existing health conditions, including up to 17 million children, no longer have to worry about being denied coverage or charged higher premiums due to their health plans, their health status. 108 million Americans have received free preventive services, and 7.9 million seniors in the donut hole have already saved $9.9 billion in their prescription drugs, an average savings of $1,265 per person. So while I certainly appreciate, as an academic exercise, this abstruse lesson in the history of the Origination Clause, I speak for the millions of the Americans benefiting from the law today and urging my colleagues to move on and address the real issues facing this country. Constitutionally, this is a frivolous hearing. The three witnesses for the majority have cited no court cases. We hear very interesting testimony. I'm going to read more about the Origination Clause in the Constitutional Convention and the debates in the Federalists. I find it fascinating. But essentially, and let me ask Mr. Onik if I'm right in saying that the three witnesses in the majority are asking us to ignore 2 centuries of Supreme Court rulings and precedent on these questions, all of which point to the fact that there is simply no real constitutional question here. Mr. Camisar said the judge was wrong, but the judge was ruling pursuant to every single case that's been decided that I'm aware of in the last 2 centuries. Am I correct, Mr. Onik?
That is correct. And Mr. Schmidt said, well, the framers wanted it raising revenues. There was no primary purpose, nothing about incidental revenues. But of course, the 3 leading Supreme Court cases on that particular issue have gone precisely the other way. They have said that certain taxes, which are taxes under the taxing power, are nevertheless not for purposes of raising revenue within the meaning of the Origination Clause.
And that is well established. It's also well established that the Senate can amend to its heart's content and that there's no germaneness requirement. Correct, Mr. Onik?
I believe that is absolutely correct.
And despite the histrionics by Mr. Gohmert, is it not correct that the precise manner of amending a House bill used by the Senate has been used many times before and upheld by the courts?
It's been used many times before.
Nothing like this.
I don't think it's ever been, and it has been approved in other cases. There's no Supreme Court that specifically has looked at a situation like this. But I do think it is very, very clear when a constitutional provision says that the Senate can make amendments as on all other bills, then that's the answer. Mr. Gohmert lifts up the big bill, but in fact, if this wasn't a revenue bill, if this was some other kind of bill, the Senate could do it and does do it. And that's what the Constitution says, as on other bills. There's nothing wrong with substituting and amending.
Thank you. Let me ask either Mr. Schmitz, Mr. Kavanaugh, or Mr. Graziano, have the Supreme Court and the Congress been simply misinterpreting the Origination Clause for the last 200 years? Should courts and Congress simply ignore more than a century of precedent based on your interpretations of constitutional history?
The Supreme Court has precedents are very clear that this is unconstitutional. The Supreme Court in no court has ever upheld the gut and substitute provision, nor could they ever.
When has
the Supreme
excuse
Court...
me, when is it, you say, wait a minute. You said the Supreme Court has made clear this is unconstitutional. When is it done?
This type of amendment is unconstitutional. In all of its decisions, it's explained that this type of non-germane amendment, and by the way, all of our testimony is full of all the cases that the Supreme Court and otherwise that say that the amendment must be germane.
Basically, germane.
That a non-germane amendment is unconstitutional.
Mr. Onik, would you comment on the germaneness? In other words, Mr. Gaziano is saying that Supreme Court has required germaneness for amendments. Is that
They did
correct?
require germane in Flint v.
Mr.
Stone
Onik,
case.
is that correct?
No. There's one case that mentioned it in passing.
The most recent one in
May I ask
1990.
Mr. Onik? Go ahead.
No, they haven't required germaneness, and how could they constitutionally?
Because?
Article 1, Section 5 says the House and Senate make their own rules. The Supreme Court can't, or the courts can't go tell the Senate whether it has to have germane rules or not. It can't tell the
Thank you.
House
Let me,
whether it has
before,
to have germane.
let me, before my time expires, say one sentence. I think that this is frivolous. I think the arguments are frivolous, but the court will decide. Mr. Sissel challenged in court. Mr. Kaminer, I think, is representing him. That's the proper way to do it. The courts will decide. And we should, in Congress, be seeking to do the business of the American people instead of holding frivolous hearings commenting on court decisions that are ongoing. I yield back.